Chapter 2, New Zealand Courts, Appealing Cases and Precedent. 2.1, an overview of New Zealand's courts. In New Zealand, the courts are organised in a hierarchy. Here's an overview of the courts that we have and how the hierarchy is arranged. If you need to go to court for something, you'll start in one of the lower courts. The court you go to first depends on what happened. For example, if someone is accused of committing a really serious crime, like murder, they'll start in the High Court. However, most criminal cases are dealt with first in the District Court. Or, let's say two people have a disagreement about a contract and the total value of that contract is 200,000 New Zealand dollars. This issue would start at the District Court because it's a civil law issue that's worth less than $350,000. By the way, the term civil law is a little bit confusing because it means a legal system, like we covered in the first chapter, but it also means a legal issue related to private individuals. So like an employment issue or a contract issue, but not a criminal law issue or let's say military law issue which involve the government. So when I say the District Court deals with civil law issues that are worth less than $350,000, that's what I'm meaning. Anyway, back to the courts. You'll see that there are a range of lower level courts, authorities and tribunals. There are also the Maori courts and the employment courts. Then you have the District Court, which includes the youth, family, criminal and civil court. Then there's the High Court, which is the highest court where cases start. The top two courts, the Court of Appeal and the Supreme Court, are the next levels up. These two courts only hear appeals. These courts are really important for developing new laws and clarifying how other courts should apply the law. The Supreme Court is the top court in New Zealand. 2.2, appealing cases. If someone's unhappy with the way their case was decided, they can apply to have their case appealed. For an appeal to be allowed, someone has to show that there might have been something wrong with how the first case was decided or handled. So it could be argued that the judge might have gotten the law wrong, or maybe it can be shown that the process that the court made to make that decision was wrong. For appeals to be heard by the Supreme Court, someone would also have to show that the case is in the interests of justice. This means, among other things, that the case is generally important to the public. If an appeal is accepted, the case will go to the next court up in the hierarchy. A new judge or judges will then rule on the case again. The appeal system makes it fairer for people, because if you can somehow show that your case was dealt with in an unfair way, there's a way to have another judge hear that case. You're not at a dead end. 2.3, Precedent explained simply. Precedent means the cases decided in courts at the top of the hierarchy about the law create the law for all of the courts beneath that court in the hierarchy. Let me explain what I mean by about the law. So judges make decisions about both the facts of cases and the law of cases. For example, a judge might make a decision that yes, that person holding the knife was the person who killed that person and they are therefore guilty of murder. That is a decision about the fact of that case. Judges also make decisions about laws. They do this by deciding how statutes, or laws made by Parliament, should be interpreted and applied. They also sometimes create new laws by what they decide in their cases. Precedent means that if a court makes a decision about the law and a similar problem comes before a court that is lower in the hierarchy, that lower court has to apply the law in the same way that the higher court applied the law. For example, if the Supreme Court decides on a case that creates a new law or interprets how a statute should be applied, all of the courts below the Supreme Court have to follow that law. So if a case with similar facts comes before the District Court, they would have to apply the law in the exact same way that the Supreme Court applied the law. 2.4, some more rules about precedent. Courts do not have to follow the law made by their own court. So, if the Court of Appeal makes a new law, the Court of Appeal does not need to follow that law in a different case with similar facts. However, judges tend to follow the laws created by their own court anyway for consistency. So it's highly likely that they'll follow that law unless there's a really good reason not to. Also, courts in New Zealand do not have to follow decisions made in overseas jurisdictions like England or Australia. These cases can be persuasive, but they are not law in New Zealand.